A very good morning to one and all. In today's series of international law, we would be starting with understanding the definition and nature of international law. So, when we try to understand what is international law, by a term we can understand that the law which is being made for the nations. Okay, so international law is law for the nations. So there are various definitions. Why do we need international law? Basically, when we see that after World War One, we realize that it is very important that we need to maintain that peace. And League of Nations was been established, but League of Nations failed to stop the World War Two. After World War Two, United Nations organization was been established. So international law actually plays a very important role in order to maintain peace in the world. So now we would start with the definitions of international law. Prior to understanding, we should understand how international law of various jurists, perspective of various jurists. International law can be categorized into two. One, international law as a real law. Set of jurists who have stated that international law is a real law, whereas the other set of jurists have stated that international law is not a real law. In real law, we have seen Halls, Lawrence, Pollock, Hugo, grocers, whereas in not a real law, there are jurists who have stated like such as John Austin, Hobbes, Holland, Bentham. First, we will start with why certain jurists have stated that international law is not a real law. First thing, what the theorist or the jurist of positive law stated that is, in order to constitute a sovereign law, as according to Austin, what he stated is, law is a set of rules and regulations which are being made by an intelligent being over another intelligent being having power over him. Basically, what they state is, in order to constitute a law to be a sovereign law, there must be a territory, well-defined territory. There must be well-defined population. There must be a defined government which makes the laws for the people. And if at all there is no one to follow, like if at all any person doesn't follow the rules and regulations, there must be sanction that is to be that it has to take place. Now, there are the basic philosophy or the thought process of these philosophers towards considering why international law is not a real law is that law is the command of the sovereign enforced by the superior political authority. Okay, so the first John Austin said that international law is not a law, but it is just a positive morality. Holland stated that international law is a vanishing point of jurisprudence. Bentham was the first person who has coined this term of international law. So, if at all someone asks you who has coined the term international law, it is Jeremy Bentham. He has also categorized international law into two types. One is public law and private law. So, out of the definitions or the philosophy thought process, we can derive that where these philosophers stated that international law lacks an effective legislation, executive machinery, potent judiciary, and sanction, due to which international law cannot be considered to be a real law, and thereby, as it is not binding upon all the nations. Thereby, these philosophers stated that international law is not a real law. We discuss why certain philosophers who have stated that international law a real law. Halls and Lawrence were the first people who stated that international law has been followed and enforced just like positive law, derived from customs and precedents, so it is a law. They stated that these international law are law because the evolution of these international law are from customary principles. What are customary principles? These are the usages which are being enforced by law, which are recognized by the society, and these are practiced continuously without any gap. So these are general customs that are being recognized all over the nations. There are certain precedents that are being seen, and thereby the evolution of international law has taken place. The second set of definition was given by Pollock, where he stated that recognized by a political community as binding them, and international law satisfies this condition. He stated that international law is considered to be a real law because these are recognized by the political communities like the sovereign political authorities of different states have come together and they have recognized this to be an international law. Thereby international law is considered to. Now comes Hugo Grotius, who has been considered to be the father of international law. Who has coined the term international law for the first time? It is Jeremy Bentham. But who is considered to be the father of international law? It is Hugo Grotius. What he did is he simply divided law into two types. One which is positive law. Positive law as in the law which is being made by humans. A man-made law has been considered to be a positive law. And the other one is second set of laws are natural laws which are evolved from nation. Natural. Naturally they are evolved. Naturally they are recognized. Right to breathe is a natural law. Right to live is a natural law. So these are natural laws which are evolved naturally. So now again the positive law has been divided into two. One is the human law and the other one is the divine law. As I said, natural law is by nature. Now let us discuss the positive law which is divided into human law and divine law. This human set of human laws are again divided into two. One is the civil and municipal law and the other one is the law of nations. Civil and municipal laws are those laws which are being recognized within the territory, like for example the Constitution of India. It is the constitution which is being formed and which has been given a sovereign authority to make the laws within the territory of a particular country like India. Constitution of India is being followed only in India. It cannot be followed in USA, Canada, UK or France. It is only abiding to the people of India. That is why the preamble says, we the people of India. It is only for the people. So municipal laws are those laws which are called domestic laws. And the laws of nation, which can also be called as international laws, are for the for now we will try to analyze the definitions of different philosophers, the way they try to explain what international law is. Okay, so the first definition is of opinion. What he stated is law of nation or international law is the name for the body of customary and treaty rules which are considered as binding by the states in their intercourse with each other. So from this definition we can say that what is international law? Simply this definition says that it is the body of customary rules and treaties which are considered to be binding by the state. He has only emphasized that the international laws are certain customary rules, certain treaties that the nations come together and sign, and these are binding only upon the nations. Okay, he has specified the limit of the definition was subjected to states itself. States as in the countries. It has been subjected to countries. Now the other set of definition by Burleigh, what he stated that is the law of nations or international law may be defined as the body of rules and principles of actions which are binding upon civilized states in their relation with one another. So Burleigh also stated that these are the set of rules and regulations, a body of rules and regulations or the principles of actions which are only binding upon civilized states. Even in this definition, he only focused that the binding authority of international laws are subjected to the nations, civilized states only. The third set of the third definition is of Gray, where he stated that it is usually to regulate the conduct of the states. Okay, so what are these international laws? These international laws are only to regulate the rule, are a set of rules and regulations which are being framed in order to regulate the conduct of the state. Okay, so out of this is the first set of definitions that we are exposed to while we try to understand international law, where Opinion, Burleigh and Gray try to explain that that the body of customary and treaty rules which are binding upon the civilized states to regulate the conduct of the states in their intercourse with each other. So, according to them, they stated that international law is certain something, but something such as customary and treaty rules which are a binding force in order to regulate the conduct of the states only. They are only emphasizing upon the states. The second set definition that we will discuss is of Sir Robert and Sir Robert Jennings and Sir Arthur Watt. What they stated that yes, we agree that international law is subject matter. States are the subject matter of international law. But what they stated that look, no only the states are subject matter of international law is not correct. They have extended along with the states, it is also the international organizations, and to some extent we can also say that the individuals are also the part of international law. So according to Sir Robert Jennings and Sir Arthur Watt, they stated that the international organizations, nations and individuals are the part of international law. Next comes S.C.H. Warzenberg. I can't spell it, so I thought of remembering his name as Burger. And see, as you can see in this image, like burger is containing all the stuff. So even his definition is considered to be an umbrella definition, where he expanded the scope that international law is a body of legal rules which apply between the sovereign state and such entities that have been granted international personality. So basically he stated that any personality which has been recognized as an international personality will come under the international law. So basically this definition covers the states, it also covers international organizations, it also covers individuals, and it also covers anything which has been recognized as an international personality. So these are the three sets of definitions that we need to remember. Now, what this lady is trying to think. When we try to understand this nature, the nature says that out of all these definitions, we can understand that the international law is in fact a real law. Okay, we can consider now that international law is a real law. Maybe a weak law, but it is a real law. But why it is a weak? I didn't understand. But when I tried to analyze it, I basically found that it is not so effective as municipal law. Yes, we cannot understand like how the authority of a state can emphasize upon its individual. The same way international law fails to emphasize its authority upon the nations. Second, it binding only if the states agree. It depends upon the states. If they want to follow, they will follow. If they want to become a part of the treaty, they are. But they are. It is not mandatory that every state has to become the part of any treaty. So there is a lacking of binding force upon the states. And the third one is lack of enforcement of the decisions of international law. We cannot properly see that any decision which has been given by international law is a binding force. Enforcement, there is a lacking of enforcement. So these are the three reasons which I think that yes, I can accept that international law is a real law, but on the other hand, it is considered to be a weak law. Now, when we talk about the basis of international law, these are some certain set of bases, such as how the international law can be evolved. First thing is naturalistic theory. It has been evolved through customary practices. Naturally, it has been developed. Customs were there. These customs were continuously being followed, and then these customs came into usage. Then the usage was being recognized by the law, and then these laws were being codified, and in this way naturally it has evolved. Okay, positivist theory is what I have stated, that positivist codification of law they were talking. Human law must be made by the sovereign authority, what Austin has stated, command, sovereignty. They have formed a political organization. So positivistic approach was also been there. Consent theory is a theory where the nations have given consent to a particular treaties. They have given consent to be imbibed to any conferences that are taking place, international conferences that are been taking place. So these are certain consents that have been taken place. And the fourth one is auto limitation theory, where you don't give your consent but voluntarily restrict yourself that I won't infringe certain rules and regulations that international law has set for all the nations. So there are certain nations that they don't give their ratification or consent to a particular treaty or an agreement, but still on the other hand they do not violate. Voluntarily they restrict themselves and they do not violate those rules and regulations. The fourth one is the fundamental theories. Fundamental theories are certain which are generally accepted. So the generally evolved theories like the fundamental right to life is a fundamental right which has been recognized. Right to good health is a fundamental right. That means general principles of law that you actually see all over the nations, all over the world. The last set is Pacta sunt servanda. This is very important. Pacta sunt servanda means treaties shall be compiled with in good faith. That is, whenever a treaty is being signed by the nations, it is not just a signature. They should be binding those treaties with a good faith. So these are certain bases of international law that we need to generally understand. So in this video we have understood that how international law, what are the different philosophers thinking of international law. We have categorized international law, understood international law in two perspectives, whether it is a real law or whether it is not a real law, and why it is to be considered to be a real law, why it is to be not to be considered to be a real law. Then we have discussed how Hugo grocers has divided international law in its part. Then we have defined the evolution of definitions of international law. Opinion, Gray and Burley gave their own perspective which were only limited to state. Later, Robert Jennings and Sir Arthur Ward given their definition where they expanded the scope of international law not up to the state but also to individuals, some extent to the individuals and also to international organization. Then Mr. Berger stated that it is a international personality. International law is an international personality. Then we try to understand what is the nature of international law, and finally we conclude here by stating of the basis of development of the international law. So thank you so much for patiently listening to the video. If you like, please like, share and subscribe to KALAW. And also please comment and suggest how should I develop more or any other additional definitions that I need to add. Thank you so much.